Hello and welcome everybody, whether you're watching live with us today or you're watching this later on YouTube. We're excited that you're here as we jump into paragraph 12. We're going to look at all things in and out of paragraph 12, answer your questions, and try to give as much information as we can. For most of you know me already out there, but I'm John George. I'm the current co-chair of the TREC Broker-Lawyer Committee that drafts and revises the contracts on behalf of TREC. I'm also a 17-year attorney, practiced real estate law for a long time, representing from buyers and sellers, brokers and agents. I'm also married to a broker who kicks me in the butt and says, "Stop being a lawyer. Let's get the deal closed and keep it simple." And I also have a company special provisions as well that I'm getting off the ground now. But I want to say thank you to Kiersten Crawford for co-hosting today and helping with the session. She always helps keep things moving forward. She's the current chair of the Professional Development Committee at Texas Realtors, and she's also an owner of Halo Survey. And so as we go through today, keep in mind is for informational purposes only. It's not legal advice. And we hope to answer your questions, but as you ask those, please put them in the chat and try not to use any specific names or amounts. We'll ask you to unmute, and so we can have a dialogue back and forth on those questions. But if you have any questions, you can start putting them in the chat now or as we go through this. But with all that said, we'll go ahead and get started. Okay, so on the agenda today, we're going to be discussing paragraph 12 and how it interacts with various other provisions in other documents that are maybe not TREC contracts, but the Texas Realtor forms. Keep in mind that the TREC contracts are developed by the Broker-Lawyer Committee and approved and promulgated by the Commission. Separately, we have Texas Realtors, which is the trade association. They have their own forms, their own processes. And those forms work together for us as brokers and agents to use. But we're going to go through the differences between those, the practical considerations to keep in mind, and of course, take your questions. So to start with the base of what is paragraph 12, let's look at it from the 10,000-foot view first. It's the paragraph of the contract that specifies the settlement and other expenses that are to be paid by the parties. And if we look at subsection A, it's split into two subsections from there. The first of which indicates what the seller is paying. And the second paragraph is what the buyer is paying. The changes, of course, that we'll be going through, and I think are the focus on top of everybody's mind, are what the seller is paying in 12A1 and the new language that we added in subsection B. And when I say we, I'm speaking today on behalf of myself, not the Broker-Lawyer Committee. But when I generally say we, I'm referencing back to the changes the Broker-Lawyer Committee has made. So let's focus first on paragraph 12A1. This is the paragraph that specifies what the seller is paying as part of closing. What we're going to have on your screen in these slides, and these slides will be made available on our Facebook page, Special Provisions Facebook page, and this YouTube video will be made available as well. But what we have is the paragraph of 12A and then what the seller is paying. The first subsection of 12A1 has a list of expenses, which includes brokerage fees that seller has agreed to pay. And that's really the focus of where the concern has been is, what does this broker fees that the seller or later on the buyer agrees to pay, and how does that fit in? Well, in this first section A, it's meant to reference the fees that are listed in the listing agreement, which is typically the Texas Realtors Form 1101, and also fees that are in the Texas Realtors 2401, which historically was used in FSBO transactions and became in a new prominence with the other form changes. But that's the agreement between the seller and the buyer's broker, where the seller is paying directly over some amount to the buyer's broker. Now, I'm going to dive into those forms here in a second. But from a high level view, paragraph 12A1A is what the seller's paying directly out of their pocket for these expenses. And I want you to keep that concept in mind as we go forward of whose pocket this is coming out of, because that will help you understand how much in total the parties are paying. So if we look at what the seller is paying out of their pocket under the first form of the listing agreement, the new Texas Realtors listing agreement is broken into a couple different sections. And this is important to lay the foundation of, because there's a cautionary tale that you might unintentionally over obligate your seller if you're not careful on how you structure your deal and what paragraphs that you actually use. So if we look at the listing agreement for a minute, under paragraph 5, if you use 5A, there's a new section that's revised compared to the listing agreement we're used to. The old listing agreement used to say what X amount that you're charging the seller as a listing broker, you keep no matter what. You keep the entire amount. That has now changed into two different methods. One of which you keep the entire amount, the other one which you have to net the fees. So if you use 5A, that's the situation where the seller is agreeing to allow you to compensate another broker in a broker-to-broker compensation agreement. And that used to be the old MLS agreement that we all just were on somewhat of autopilot. It was done easy for us, established. We didn't have to think about it. Now that the MLS offer compensation has gone away, we have these new forms like the 2402 and broker-specific forms that form that broker-to-broker agreement. But under 5A, if there is another broker and you don't use the amount the seller has authorized you to pay in 5A2, you have to net those fees out. So you don't get to keep that entire X% anymore if you don't pay what you've agreed to pay the other broker as cooperative compensation. So it's X minus the amount that you didn't pay under 5A2. But if there is no other broker, or you're in an intermediary transaction, you still keep the entire X. You keep the entire amount that's listed in 5A1. There is no netting like you would if you had another broker and didn't pay them the full amount. Separately, there's paragraph 5B. And 5B is when the listing broker is not agreeing to pay another broker any amount. And in that case, of course, you would keep the entire fee that's listed in 5B. This concept of the seller, this is the amount sellers agreeing to pay out of their pocket. And so when we talk later about the listing agreement fee and how it ties into the 2402 amounts, then it is really important to keep that in mind of ultimately what the seller is agreeing to pay in the 1101.
Okay, John, before you move on here, I just want to put this out there. Yep. So when a buyer's agent asks, this is what we get, what's the BAC? And what I know I've run into is it all goes back to what's here. So can you touch on that a little bit?
Yes. And so remember, this agreement contains binding obligations on the parties and sets expectations. And so when you're executing this with the seller, make sure you, one, understand yourself the terms and that your seller understands them as well. In this paragraph, if you use 5A, and in 5A2 specifically, you're agreeing to offer cooperative compensation, the BAC, the buyer agent compensation. And you list a specific amount, right? So there you're telling the seller and you're agreeing with the seller that when I market your property, I'm going to offer other agents compensation if they bring buyers to the table. And so if you use that paragraph, make sure that you understand that you're agreeing to do that and take the steps necessary to structure the deal properly to account for that and to use the form to establish that relationship. As we'll get into in a minute, the TREC contracts do not establish an agreement between brokers. The only one that has it is the farm and ranch contract at the end, where there's a ratification of the fee between the two. But in the 1 to 4, in the unimproved property, and in the new home contracts, there is no broker-to-broker compensation agreement. And now that we don't have the MLS agreement, you have to establish that somewhere else such as the 2402. And we'll get into later today in the slides, the 2402. But stepping back again, the amount in the listing agreement is the amount the seller is agreeing to pay. And that's the amount that is meant to be included here in paragraph 12A1A. That's that reference here, broker fees that the seller has agreed to pay. The 2401 also is a direct agreement out of the seller's pocket to pay an amount. And then 2401 establishes that amount to the buyer's broker. Historically, this was used when there wasn't a broker on the seller's side, right? There wasn't a broker to make a broker-to-broker compensation agreement in MLS. When we had the MLS go away, this form started to be used as one of the options more and more, but I think we'll drift back to being used largely in for sale by owner situations. But again, it is coming straight out of the seller's pocket over to pay some amount to specifically the buyer's agent or buyer's broker in this case. So that goes back to the amount under 12A1A. This is an amount out of the seller's pocket, paying some expense directly. If we go forward to the new language that's in 12A1B, and this is where much of the confusion arises. This is a separate and different amount than what we just went over in 12A1A. And specifically, if we read the language, it's the following amount to be applied to broker's fees that buyer has agreed to pay. So it's a contribution. We look at, as most of us know, it's a seller contribution over for a specific purpose. So this is where the seller in the contract is agreeing to contribute an amount for the specific purpose of broker's fees that buyer has agreed to pay. Well, what is that amount? Right. So where do we look, and what do we mean by the broker's fees that buyer has agreed to pay in this specific subparagraph? The reason that it has the language in there that broker fees that buyer has agreed to pay is meant to set a ceiling on the amount that the seller is agreeing to pay in this paragraph or to contribute in this paragraph. So if you agree to pay X amount as a seller in this paragraph, but the buyers actually only agree to pay a lesser amount to their agent, well, the seller's only going to be responsible for paying that lesser amount. That's what that language in there that applied to broker fees that buyer has agreed to pay. That is effectively a cap, whatever amount that buyer has actually agreed to pay. They can't collect more than that. If you look in terms of the settlement agreement and the new MLS rules that are out there, right? It has some obligations in there to have definitive agreements with buyers to make an ascertainable amount that's conspicuous to the buyer. But they require them to have written agreements, buyer's agents have written agreements, and those should establish the amounts that the buyer agrees to pay. And the amount the seller then in this paragraph is agreeing to contribute is capped by that amount in that agreement. Now, note that those agreements, buyer representation agreements, can be amended. But if you have a lesser amount in the buyer rep agreement than what is initially put in this paragraph, it's going to require a discussion between the buyer's agent and the buyer to say, look, they're offering more. Here's why I should keep that, why we should amend this to let me keep that as buyer's agent. And then you're going to have to sell your worth. You're going to have to justify it to them. And they can always tell you, no, my buyer's rep says this. We agree that's what your compensation would be. I could get the benefit of that extra amount. Let's take that off the sales price or negotiate some other repairs. I don't want to pay that in compensation. So circling back to the core of the contract, this 12A1B is meant to be a contribution straight out of the seller's pocket towards buyer's agent compensation, and the amount they ultimately end up contributing is capped at the amount that the buyers agree to pay their agent. This slide, I've included a lot of little information. You don't have to worry about squinting right now. These will be available later, but I wanted to include it in the presentation material so it'd be easy reference later on. And this is generally describes at the beginning the situation that I just went through. But I wanted to throw out the cautionary tale of it, because there's a lot of confusion on whether amounts that are listed in the 2402, the broker-to-broker compensation agreement, should be included in 12A1B. And they should not. They're completely different amounts. The one that's listed in 12A1B is out of the seller's pocket, contributing to buyer's agent compensation. The 2402 is broker to broker. The 2402, the listing broker out of their pocket is agreeing to pay the buyer's broker. And so it's a different amount that is added together or on top of 12A1B. And so if you put X amount in 12A1B as a seller contribution, and then you also executed 2402, that the seller then has to fund via the listing agreement, those two amounts are stacked on top of each other. That seller is going to be responsible for both X in 12A1B and Y through the 2402 that they're required to separately fund via the listing agreement.
I think it's important to note here too, John, is that as this evolves, you may have a seller or, well, in your situation with 2402, the listing broker who offers an amount. And it may not be what the buyer wants wants the seller / broker, buyer's broker, to get paid. So in other words, the listing brokerage could offer some money up on 2402, but the buyer says to the buyer's broker, hey, I want to ask for more money because you and I have a buyer rep agreement and what was offered up doesn't cover it. So there, you may be intentional as this involves that the buyer tells their buyer agent, hey, use 12A1B and go ask for more money. It's not enough to cover what's in my buyer rep.
Exactly. And that's the one situation that is going to be common where both the 12A1B and the 2402 should be used. Right? The 2402, which we'll get into here in a little bit, should be executed up front before the parties execute the contract. And it already establishes an amount that the buyer's broker will be paid. And that's coming out of the listing broker's pocket. But in the situation where that doesn't cover all the expenses and the buyer says, to make this deal happen, I need you to pay all my fees. That's where you can use 12A1B to add that additional amount on top of what's already in the 2402. And say, okay, if I'll only agree to pay this portion via 2402 to cover these buyer broker fees, let's make the rest of it go in 12A1B so it's complete and all of them are covered. Or some amount, doesn't have to be the complete amounts. It's whatever amount you negotiate. But when you're looking at structuring a deal and entering into a transaction, it's probably one of the most important things, if not the most important thing, for the buyers and sellers to understand the financial aspects of it. And that financial aspect of the 2402, which the seller generally funds via the listing agreement, being one pillar. Separately, the paragraph 12A1B, which the seller is funding directly out of their pocket to the buyer's broker, are added together. And so both sides need to understand that, whether you're a buyer, knowing how much is actually being paid of the fees that you're required to pay your broker, and the seller to know what they're coming out of pocket for. And the common mistakes here are duplicating, putting both the same amount in 12A1B, thinking that that's the amount that the buyer has agreed to pay. That's what the paragraph says. But that's not what it says. It's meant to be as a cap, as a cap on the fees the seller's paying in 12A1B. So then they also be responsible for both.
Yeah, and it's also important to note here too that not all brokerages are offering a broker-to-broker agreement, which I know you'll talk about as you move further into this, but I don't want to overlook that because many brokers are electing that route as well.
Exactly. And some that are even offering it structure their deals in a different way, right? So let's say you offer the BAC or broker compensation, but you get a contract in that has all the amounts just in in paragraph 12A1B, right? And you haven't established that broker-to-broker agreement. Well, in that case, you need to make sure you discuss it with the parties so they understand. But that's okay, because you have just the one amount 12A1B, and you haven't done the 2402, or you haven't done some other broker-to-broker compensation agreement. I wanted to throw another cautionary tale here is make sure you're very clear in your discussions between brokers on what the cooperative compensation will be or will not be. Unlike compensation agreements for commissions between buyers and sellers and brokers, broker-to-broker compensation agreements do not have to be in writing to be enforceable. And so as brokers and definitely in monitoring and educating agents, we need to make sure that their email correspondence, their text correspondence, their phone conversations are very clear and specific, and don't bleed over to an argument by the other broker that, hey, by this phone call, you agreed to pay me X amount as cooperative comp. I want to enforce that. Or by this email exchange that we have between each other where you offered it, we established that relationship. And then later on, you decide, well, we don't want to do as a whatever side of the cooperative comp, we want to put it in the contract, 12A1B. That's okay, but you need to make sure that that other agreement hasn't already been established between brokers, intentionally or unintentionally. And if you have any doubt, put it in writing, put it in an email saying, just so we're clear, the total amount that is being offered here is only 12A1B. We're not doing broker-to-broker compensation. And we'll make sure that any of our communications before this haven't led to that impression and haven't established it. It's really easy for a cleanup email and get that acknowledged from the other side, so you don't run into this situation, especially right now in the interim period, of having a misunderstanding that ultimately hurts the parties at the end. And then what is that going to lead to? A TREC complaint, a Texas Realtors ethics complaint, a very unhappy client that we want to make sure we're clear. And there's a lot of easy things I think that could be done with communication and with making sure it's established in writing the understanding up front. This would become less of an issue as we, as a profession, learn these forms and as everybody's understanding rises. But for this interim period, we're going to have a lot of confusion and a lot of individuals misinterpreting the contract. So we have to be very careful on that. We'll come back around. I know there's going to be a lot of questions on that from different angles, and everybody understands things in their own way. And when they ask it a certain way or they hear it a certain way. So I want to make sure we circle back around and have you ask your questions on that particular issue for sure. But to get everything in paragraph 12 on the table, we now have a new 12A1C. This is a modified version of our old 12A1B language. And this is our general seller contribution, where the seller is agreeing to contribute some amount to other buyers' expenses. And this is very important, the use of the word other here. There's a question on whether the amounts that are listed in this paragraph can be used not only for buyers' expenses, which is a defined term, but also for broker compensation, for buyer agent broker compensation. And this cannot be. The use of the word other is meant to be all these other buyers' expenses except for the broker fees that buyer has agreed to pay under 12A1B. It's the catch-all at the end. Is we use other to mean any other the buyer's expenses other than that. And the justification of why we did it this way, as I say, with the Broker-Lawyer Committee's discussion, was some sellers are not going to want to contribute to buyer broker compensation, but they're willing to contribute to all the other fees that are out there. That's why we split out 12A1B to make that specific concession if the seller was willing to do the contribution for buyer broker compensation.
Hey, John, can we back up just a little bit, because just to put some clarity around your comment, Rhonda was mentioning that we've been under the impression she mentioned that David at Texas Realtors said that to established broker to broker compensation, that it needed to be in writing. But I'm hearing you say, no, not necessarily. Can you elaborate on that? Feel free to unmute Rhonda as well.
Sure. And there's a provision in the Texas Occupations Code. I'm trying to remember off the top of my head, maybe 803, 1101, 803 maybe, that says that exempts agreements between license holders from the written requirement, from the requirement that the contract be in writing. And so there's a specific exemption for agreements between license holders from that written requirement. Now, it's absolutely a best practice to do it, but you have to be use caution in understanding that it can be established in an oral agreement. If we look outside, and we have a new context now for cooperative compensation, but historically, if you remember referral agreements and things like that were enforceable when they were oral. Now it's kind of an expanded understanding or focus on that particular issue. And I always get deer in the headlight looks when I mention that, but and I can find the exact site to it here to provide everybody.
Okay. Perfect. Yeah, we'll get that 803 whatever number pulled as a reference. All right. Keep rolling.
All right. So now we're looking at C being amounts that are other buyer's expenses besides the brokerage fees that buyer has agreed to pay. And what are those? One thing that I think was overlooked in the past was there's a definition of buyer's expenses that is contained within the contract. And that is in paragraph 12A2. That section that says what the buyer is agreeing to pay. And some of the confusion that's out there in the belief of why the amounts in 12A1C, which you can still see on the top of this slide, why those amounts in some people's minds can be used for buyer broker compensation is because we added a line within this long definition for buyer broker fees. But remember, it's other buyer broker fees. We've already addressed in 12A1B the amounts eligible to do for that specific purpose. And so 12A1C is meant for everything else that's listed within this definition of buyer's expenses. And it's such a long definition, it includes pretty much every expense that we typically would think of as a buyer's expense in a transaction. So I don't think there historically was a lot of thought that was put into it of what the actual contribution from the seller could be used for. But now we have to be purposeful, especially with the amount the seller is willing to contribute towards buyer broker compensation. Jumping forward to the page 10 disclosure. And I can't say this enough, that it's informational only and not enforceable, period. It should only list, when used properly, it should only list for informational purposes the amount that the brokers have agreed to in a broker-to-broker compensation agreement. And that's the 2402. But again, it doesn't matter what's in here. It doesn't change anything. It's informational only.
And I'll say this, there's a lot of confusion right now going on about this. I took a call from a broker no, she was an agent, and she said she was the listing agent. The buyer agent brought an offer and said, well, our broker doesn't want us to use 2402. So the listing brokerage was actually offering a broker-to-broker compensation. The buyer broker said, nope, we don't fill out 2402. But here's where it gets worse. So the buyer agent just put her amount on page 10 and was thinking that would satisfy her compensation. And I said, well, you just are going to have to kindly remind them that this is, as you have highlighted, disclosure is for informational purposes. And it just doesn't mean a whole lot, other than a little communication maybe to a title company. So, the buyer's agent was not securing their compensation with the seller and or broker compensating them, only trying to use this. So I I'll just go on the record. I hope this goes away sooner than later because it's doing nothing but creating drama.
Well, and we attempted as the Broker Lawyer Committee, or at least suggested, this was 4, 5, 6 years ago, to actually take out this section. Because there was at that time confusion between, well, what controls that the MLS amount is different from the page 10 amount. And we didn't have at the time this additional sentence in it. And when we suggested it be taken out and the proposed forms went out, pitchforks came out. And everybody's like, what? Well, how are we going to determine what the commission is? Which really proved our point because it didn't matter back then like it doesn't matter right now. But taking into account all the comments we received, we put the language back in and we added this additional sentence that made sure that it stated it's informational purposes only and doesn't change the previous agreement between brokers to pay per share or commission.
So let's just take this opportunity then to also highlight it is going to be very important for the brokerages to communicate to title or an attorney's office, whoever's closing it, who is paying what. Because it's not the one lane highway. The seller is not always paying. And I'm already hearing stories where buyers are paying, maybe a part of the amount and it's not being communicated to the title, which means when they do the closing disclosure and it goes to the lender then kicks it back because they're saying, well, no, we didn't know about this. And then they have to redo the closing disclosure. So communication is key. And I've had people say, well, how do I tell them what's paid where? Well, it's either in the contract, you have separate agreements, listing agreement, buyer rep agreement, or for that matter, a brokerage can send an invoice to title. So anything else to add on that?
No, and I feel the pain because I owned and operated a title company for almost 4 years. In both in directly closing deals and managing the company. And it was always a struggle, and especially in certain markets, to get this information early in the process. And as escrow officers and assistants, there's so many requests I would have to go out to brokers and agents of tell me what the fee is, put it in writing. Ultimately, getting a CDA at closing or an invoice or something to show the exact amounts that are being paid. Make it easy on the title company by letting them know up front. This page 10 disclosures, one place that at least would list the broker to broker comp that's been agreed to if it's truly has been, right? And then otherwise, I'm seeing title companies develop their own forms. There's lots of different requests out there for the actual underlying agreements to be provided, whether it's the buyer's rep or the listing agreement. And remember, there's nothing under the law that requires that to be disclosed or provided. Talk to your client up front and your broker or whether you will provide it. Now, practically, certain lenders' underwriting guidelines and certain title companies are requiring it internally. Right? It's not the law, but they can require it under their own guidelines that then become a concern. But so it is something early on to address and make sure everybody's clear on who's paying what. But this provision itself, like back then, just now, shouldn't be relied upon by anybody, including title. Right? It's just informational purposes to get it out there. It should be accurate, but if it's not accurate for any reason, it doesn't change the actual underlying agreements. And as a quick plug on the Broker Lawyer Committee, we always like to pull out and I keep them handy, all your comments of all this, pages and pages. This is one red well, but all the comments. This is one we received a lot on how much disclosure to put into the contracts. How much do we list in terms of who's paying what? And we took into account considerations from a whole bunch of different sides, from put everything in, a whole separate addendum with all the amounts of who's paying what to whom, and to not having anything in the contract period, not listing anything or requiring any amounts. Privacy concerns, confidentiality concerns, business concerns, all that we consider, which is beyond the scope of today, but know that we vetted that out and made it the best decision that we could at the time, considering all those concerns. But again, page 10 doesn't mean anything in terms of the actual agreements between the parties. It's informational only.
Okay, so I'm going to mention Hattie pointed out. Okay, so let's say somebody puts something in pay on page 10, and nothing's anywhere else, but it's on page 10. And the buyer, remember, I get it. It's the parties to that contract are the buyer or seller. Is that some form of acknowledgement, though? Because you made a point. It doesn't have to. You with me? I could see where it could create potential
So
litigation.
we're looking at fighting this in court later on, right? If
Yeah,
somebody
it's the
that,
what if game that we haven't played out in court yet.
and if, let's say if I make the argument of, as a buyer's agent, no, listen, broker, you agreed to pay me. We had that phone call yesterday before you entered this contract and you agreed to pay me. And look, I even put it in the contract. You didn't change that up in the contract. You left it in there. That page 10 doesn't establish the agreement. Can't be used for that purpose, but it definitely can be evidence of some other agreement that was made. Right? And so if it comes in incorrect, you don't want to have that go uncorrected or unsaid of what the amount actually is or is not. And because it can be used as evidence later. It's not the agreement, doesn't establish the agreement, but it absolutely can be used as evidence to show what the agreement actually was, especially in the context of oral agreements between brokers.
Okay. 2402 next.
2402 is next. So 2402, which again should be listed on page 10, doesn't cover, should be listed on page 10, but this is a direct payment from the listing broker to the buyer's broker. And that's what distinguishes it from the other amounts in paragraph 12. Right? Paragraph 12 is out of the seller's pocket directly. This is out of the buyer's or the listing broker's pocket directly. It may be funded by the seller via their separate listing agreement, but ultimately this is a payment by the listing broker to the buyer's broker directly. And so that's why it differs from that, again, paragraph 12A1B. And if you have to look very carefully on the amount the seller is agreeing to pay in the listing agreement, and ultimately what you agree to in the 2402, and then add that to any amounts in paragraph 12 to make sure the seller understands the amount that they're ultimately agreeing to pay, and to understand the finances on their side. And this should be signed in advance, right? There's a lot of practices out there that, if you look at historically, the MLS agreement, that was established in advance. You already agreed to the terms of that agreement by subscribing to the MLS. And then by putting the amount for cooperative compensation MLS, you made that offer. That buyer's brokers accepted by bringing the buyers to you. Right? That doesn't exist anymore. So how do you make that offer and how do you establish it? You advertise, you have to be careful in your advertising, how you actually do it. But ultimately, establishing it in the 2402 or some other similar agreement is the way to have that contractual relationship. The problem is when you look at whether that's actually attached or signed before you sign the contract, or buyer and seller sign the contract's the issue. Let's say you send over the contract and then as a separate attachment the 2402, but only the contract comes back signed. That's an enforceable contract. It's signed by the buyer and seller. There's no changes. Everything's been initialed. That there's counter offers, but that 2402 is never executed. Remember, brokers are not parties to the contracts. That's a separate agreement. And so you could have just then put your buyer in a position of not having that cooperative compensation pay for some of their fees. Some are putting it as addendums to the contract, right? Using paragraph 22 and attaching it as an addendum. I think that's a very risky practice to do because for a couple of reasons. One is the contract, if you look in paragraph 1, says the parties to this contract are the buyer and the seller. The brokers are not listed as parties. This 2402 form, if attached as an addendum, not already signed, is between brokers. They're not parties to the contract. And what if they don't sign it? What if everything else comes back signed, but that 2402 with that offer? Do you have an enforceable agreement? And it's opening up the door for lawyers to argue that no, you don't, or yes, we do. And having a dispute at the end of the day, as opposed to the intended practice of establishing that agreement up front. right? It has a term of when it's valid through and from the 2402 between the brokers. It's meant to be established up front, and then you go enter the contract knowing what the finances are going to be. A practice that doesn't concern me as much, except for exposing brokers to potential more liability, is attaching as an addendum an already executed 2402. Right? It's really not part of the contract, shouldn't be part of the contract. And by attaching it, you give at least some legal argument that the brokers are now parties somehow and should have additional liabilities because of it. But at least you've established a financial relationship between the parties, right? You had that 2402 executed in that scenario. So definitely best practice, execute the 2402 up front. I would list the amount on page 10, but not actually attach it as an addendum, and make sure that that amount in 2402 added to whatever's in 12A1B match up to the total. We want to go circle back around to the entire picture there.
So Anne Marie has a question. She said, is it a new expectation for listing agents to require the buyer rep agreement from the buyer's agent to prove what the buyer has agreed to pay or not? And I will tell you, it is, and I'm sure John can elaborate, those are separate private agreements. We don't have any obligation to provide those agreements when asked. And so, John, you want to add anything to that?
I would say it's a discussion that needs to be had with our sellers or buyers up front to say, this is an agreement that we don't have to provide. And let me say the brokers too. Now, all this stuff is ask your broker, should be a qualification to everything we talk about. But it is in consultation with your broker and consultation with the buyers and sellers of saying, this is an agreement we're not required by law to provide the other side.
Yeah. And I should have clarified that directive is what Texas Realtors has provided as information in a directive. But yeah, absolutely. That whole asterisk, ask your broker, because especially right now, when you call instructors and you say, well, hey, what about this? And we have to say, well, number one, we're not a broker, but number two, brokers have had to make business decisions about how they're going to run their business. And really, it's the first big decision that they've had to make probably since buyer's representation became a thing in the mid 1990s. And so there's just a lot of routes that there's not defined answers. And kind of like John mentioned, some of this hasn't been through case law or professional standards complaints. So, a lot of this can be the what if game. So you want to add anything to that? And then I want to share one little story that I heard this week.
Sure. And I want to add the next part of that conversation after the brokers set their policy and their expectation and when entering the contract in terms of the confidentiality of it is talking with the buyer or seller on, we may not be required by law to provide it, but what practical impact can this have to help get a deal closed, right? There's a lot of paranoia on the exact amounts that have agreed to be paid. If a seller is willing to contribute some amount in 12A1B, they may justifiably want to see some documentation of the amount that they've actually agreed to pay, that buyers actually agreed to pay. And so by having that discussion with sellers saying this could facilitate transactions, right? If we agree to provide it, it could remove some of that paranoia and make it go more smoothly. At the same time, we're disclosing the exact amount you're agreeing to pay, and that could be used in their negotiation decisions on the other side. And this goes again to, is the broker themselves willing to agree to disclose it? Right? We're fiduciaries to our clients first. These aren't confidential agreements, so if our clients want to provide it, they should be able to. But if we, as a broker, don't want to provide it against our client's wishes, we need to make sure the client understands that up front when entering the agreement. And there's business reasons. There's a lot of creative buyer agent agreements out there, a la carte services, limited representation, a lot of unique ways for compensation to describe. A lot of brokers don't want that out there. And that's the case where you need to make sure if that's the case and have that conversation with your client up front so they understand that. Because it can, in some deals, make it go smoother, or you can make it go harder each way. And maybe at the end, the buyer's lender is going to require it absolutely under their underwriting guidelines. And what that comes down to the last holdout point of of making a deal happen is just the lender needing to see a copy of it.
Sure.
You got to think that through and on that, but it's understandably not an easy situation.
I can tell you that a lot of new construction builders, they are requiring that they see that buyer rep agreement before they will pay. And just to your point, John, that's whereas buyer's agents, we need to have that conversation with the buyer and let the buyer send that agreement to the builder rather than us to limit that liability.
And there, the big takeaway for me is open conversations with our clients. We're fiduciaries to our clients, put our clients first. And before we just say no, or if we haven't talked about it up front, we need to have that conversation with them because it can have a material impact on a deal where some of these builders in their contracts are actually writing in provisions requiring it, right? And then it's a contractual obligation up front. So just a word of caution, make sure you're reading everything that comes in and are having those discussions that we need to have with our clients.
So I'll mention I got a call from a newer broker, and she said, "Hey, Kiersten, I've got this deal. We're under contract, and the house appraised for $25,000 less." And she was the listing broker. And she said, "Well, can the seller renegotiate the compensation?" And I said, "Well, let's just back up a minute here." And I'm kind of reiterating what you talked about at the beginning of this call, and that is, where is the money coming from? And I said, "Well, what agreement?" Well, she had a 2402 agreement. And I said, "Well, that's an agreement between brokers." She was wanting to have the seller. She goes, "Can the seller change their mind?" I said, "At this point, you have a broker to broker agreement. So you're going to need to, number one, talk to the broker about what they're willing to possibly do. And, inadvertently, the seller too." But it was just that mentality of thinking of it was a conversation just the seller needed to have. Well, no, you had an agreement out there that was a broker to broker agreement. It wasn't a seller buyer's broker agreement. So just wanted to kind of point that perspective and that thought out. Where is the money coming from? You've got to start there.
And that's really the foundation of it all, right? We have whose pocket is the money coming out of under these various agreements. And if you look at paragraph 12 being one pillar that's coming out of the seller's pocket, 2402 that's coming out of the broker's pocket. If the sellers agree to fund this over here, it's then going to be added together. And if we go back to this slide, right, the fees listing, the sellers agreeing to an A, pay the fees to the listing broker in the TREC Realtors listing agreement, the 1101, which can include that 2402 amount. Separately, they're agreeing to pay a different amount directly out of their pocket to the buyer's broker. And then third, they could be paying some other amount for these other buyer's expenses that are out there. Add those three, the amount from the listing agreement / 2402, the amount in 12A1B, and the amount in 12A1C for that total contribution.
Okay, I want to back up just a minute. I got a question that said, doesn't the broker get to decide who has a copy of their agreement?
So the Texas Realtors listing agreement or the buyer representation agreement does not have a confidentiality provision in it. It doesn't require the buyer and the broker or the seller and the broker to keep it confidential. Now, the broker may have a policy that they don't disclose it and they want to keep it confidential. But on the other side of it, the buyer and the seller are their own parties to it, and they haven't agreed to keep it confidential by the terms of the agreement itself. Now, you can absolutely write that in as a broker, right? It's your agreement. It's not agreement between the parties. It's your business arrangement with your client. And so if you had a concern about confidentiality, you can write that in there. But you need to make sure under your fiduciary that you're discussing the implications of that. That when you get in those deals, when you have the paranoid other side that's saying, "I don't trust you to make this deal happen, I want to see it." That's a discussion that should be had up front, especially with how big of an issue it is right now.
Gotcha. Okay, did we show all your slides? Because we have quite a few instructors on this call.
Yep,
And
Well, the slide,
So
you can
I
jump in.
wanted to see,
I
there
have one about the practical side that we can go into, I thought, after questions, or we can address it now. But there's another slide that goes into the process here of what you should look at in terms of establishing the arrangements and how you should approach that with your clients. I think it'd be good to maybe pause and see if there's any questions that we can ask, and then end on that practical side, because I think it's really important for those to understand how to establish the relationships and the discussions they should be having.
Yeah, I do want to mention that VA, yeah, Avis put it there in chat. VA does have a policy that they require a buyer rep agreement to be filed in the lender's file. I know I've been teaching have your buyer send that to the lender. So good thing to note, Miss Avis, on that. And then I think I've answered all of the questions that were in chat. Did I miss anybody's question in chat? And then with that said, especially, anybody who has a question, if you raise your hand, but especially, I know looking across the screen here, I've got a lot of senior instructors and seasoned instructors out there. You're in the trenches. I know I tried to hit some of the things that have come at me. Are there any burning adventures, questions that you've been hit with in class that are relevant to paragraph 12 that you want to ask about that we did not cover? Anything?
It's just your opportunity for a group to learn and to, let's all learn together. So,
Kiersten,
Yes, ma'am.
it's Rhonda. I got a phone call from a broker who, she was the listing agent, and the buyer broker, she sent over the 2402.
The buyer broker did?
No, the listing agent
The
sent
listing
the
agent did.
2402
It can come either way. Yeah.
to the buyer agent. It was not returned. However, an offer came in, and in the offer, they used 12(1)(b) for the seller to pay compensation. So the listing broker contacted the buyer broker and said, I think maybe you've made a mistake, because we have the 2402. We have our listing agreement where the seller has authorized a buyer agent fee directly paid by the listing broker. The buyer broker said, we are not going to participate in broker-to-broker fees. Even if we're on the buyer side, we are not going to participate in broker-to-broker fees. The listing broker was upset, emotional, saying they're interfering with my listing agreement. I remembered in teaching the ABR course that NAR has addressed the fact that broker-broker compensation can be rejected, but it has to be done in writing. So I've reached out to the Texas Realtors attorneys to ask if we need a form for that. In talking with the listing broker, I kind of calmed her down and said, let's just look at this. You want your transaction to work out. How can we make this work? Let's don't go there about whether they're interfering in your relationship. Let's just figure out how to make this work, which of course we did. They just amended their listing agreement and went ahead and had the 2402 returned, basically took it off the table, and then went with the paragraph 12(1)(b). But the point that I wanted to bring up is for John, if a broker wants to reject an offer of compensation that's been offered in writing from a listing broker, does that need to be done in writing by the buyer brokerage firm?
So if we look at the legal aspect of that up front, is what is the agreement that was offered, or what was the offer that was made? And having that established or not established is the first step. They're being offered in many different ways, and a lot of them are very vague in terms of, we're just offering this buyer agent compensation without saying how
No, this was exact. It was a 2402, and it was in the listing agreement. They offered it according to what had been agreed upon with their seller for the listing broker to pay a buyer broker fee, but the buyer brokerage was refusing a buyer broker fee They wanted it to come from the seller, even though the listing agreement was structured so that the fee would come from the listing broker.
Yep.
So
And
the buyer brokerage wanted to reject the offer of compensation from the listing broker. They were rejecting that.
They wanted it to come directly from the seller.
They wanted it to come
different
directly
best
from the
practice to
seller.
have that in writing. Now, what our listing agreement says is that we will offer it, right? We will offer buyer broker compensation. It doesn't mandate under the language saying we absolutely will establish it. And in fact, it takes into account that if we don't pay the full amount or don't pay any at all, we're netting those fees out. And so, but start with the basis of the requirement of a written rejection. I'm not sure I agree with that because there's nothing in this contract that says we absolutely have to establish it. If our listing agreement said you will do this, and the will was have an agreement with the buyer's broker, that's a separate issue that would need to be addressed. Here, we're just offering it. If the other side doesn't take us up on it, it's absolutely a best practice to get it in writing, to reject it in writing, to make sure everybody's on the same page. But if it's offered this is where the offer comes into play. Is if it's offered, just if you bring me a buyer, you earn it. Well, that's a contract, a unilateral contract that may have already been accepted. Where if it was done in a different way, several offering it in with all these terms and conditions and asterisks on how it's actually earned, and saying it's not earned, especially if we don't have a 2402 sign. In that case, you wouldn't have it established, and you could just do the 12A1B. You actually want to put it in writing that we're not doing the cooperative compensation. So it's a little bit of I think the foundation of the question on if it's in writing, or the requirement of being in writing, we have to look at that first. And whether that's tortious interference or not, I'm not sure I agree with that being tortious interference. That's an intentional way. And let me step back too. There's also some arguments that if you're parties to the contract, you can't interfere with that contract. There's a new case that recently came out. I'm forgetting the language of it, but that touches on that. So I'm not sure the tortious interference, because there is nothing that's an absolute, you will agree to do this. They're free to structure their business deals on the buy side their own way, but they need to make sure they're living up to their fiduciary duties to their buyer to tell them, I'm rejecting this offer, and here's why. And it's best to have that conversation up front of, if we get this offered in any future deal, I'm not going to accept it. Because
and I will take the opportunity to mention, for those of you that are realtor members, Texas Realtors, I mean, hopefully broker to broker, I know that's what all of us instructors advocate, that, you try to cooperate, work it out broker to broker. If that doesn't help and doesn't resolve the issue, don't forget we have the ombudsman program through Texas Realtors that you can participate and or mediation there that might be able to help. I know the inquiries for that have already increased so far this year. So that might be a resource for the brokers as well.
Can I ask a question?
Sure. Let me make one last quick comment on this other issue is having the bigger picture here. And I'm a big believer in freedom of contract. Parties should be able to establish the contracts that they generally want. There's varying different positions within the industry on what should be the requirement and what should be allowed. You have the DOJ, at least under the last administration, and I haven't seen any change in policy, that they've made their position that they don't want to see any broker-to-broker cooperative compensation. And put that in filings in these court cases. And you have NAR and TXR with their own positions, and then us is the legal professionals, which should or shouldn't be allowed under the current law. And so some of these position statements and positions on the legal arguments are colored by where the people are coming from in the industry and what their belief is in the law. And what does that mean for us as agents? Knowing it's a lot out there, but there's a process that's been set up with these forms that you can follow that I think is, if you study them and get the understanding, should be very clear. But it is going to take a huge education effort within our industry to do that because of the sheer lack of understanding. Education is more important now than ever. So So with that,
So- I was just going to say, before we take any other questions, since it's 1 o'clock, I know we appreciate all of you being here. I think John can hang out for a few more minutes, so we'll take some additional questions, but thank you all for participating. I think we've covered the most of what we wanted to make sure that you got, and this will be posted on special provisions as well, right? And then Penny, if you want to hang out for a second, we'll take your question too.
in the slides will be posted there. But it can be as helpful as we can on this issue. And I'm definitely want to take your questions that you have here. So I didn't see whose hand was up or who started. Okay, go ahead.
Okay, so because there are some companies out there that won't do broker to broker and they have their own contracts, could that be a reason if I'm a listing agent offering broker compensation to the buyer's agent, do those companies, are they not allowed to accept it that way? Is that maybe why it would have to be coming directly from the seller?
There's a lot of different internal policies within these brokers, both small and large. And I think some of the larger ones, they have a corporate policy that is sometimes even misunderstood within their brokerage. But they're free to set their own business deals. We're all in business as brokers and agents, and we're free to structure our relationships within the rules the way we want with our clients. They have certain ones have taken the stance that they're not doing any cooperative compensation. I hope they're meeting their fiduciary duties and establishing that appropriately up front. But that's something that they can set as their business practice, as long as it's within those rules. I'm not sure. Does that answer your
Yeah,
question?
I think so. I know that while we were doing this, I got a text from one of my agents saying that she just received an offer on her listing that the seller agreed to pay 3% to a buyer broker. The buyer's agent sent her a 2401, a 2402, a 2406 that we're not even using anymore. And she also put it 3% in 12A1B. So she, yeah.
All the bases there, and not to get in specific amounts or parties, but going back again, so if we go to the hypothetical of X amount that's listed in all those blanks, what have we established? We established the seller in 12A1B is going to pay X amount up to whatever that buyer's actually agreed to pay, right? We have the 2402 that if the seller's also agreed in the listing agreement to fund that amount, is paying that amount. And then you have yet a third agreement in this scenario, the 2401, which stacks on top of both of those as well. So then you do A plus B plus C equals the amount the seller's ultimately going to be paying in that hypothetical for.
So you better change the seller net sheet.
It change the seller net sheet, and as an asterisk to the page 10, doesn't matter what's on page 10, right? You can tell we're looking at
Thank you.
2402 and so I say 2402 / listing agreement in the 2401.
Okay, thank you.
2401, just as another aside here, operates functionally the same way as the 12A1B in terms of the payment, straight out of seller's pocket to the other side. But they're separate agreements and will stack on top of each other. Same type of payment.
All right. What else? Any other additional questions? Is it Carrie?
Carrie.
Hi, Carrie. What you got?
Okay, so I know you've said this a million times, but I'm trying to dumb it down and wrap my brain around it. So what's got me worried is at the very beginning, just now, you're talking about over obligating our seller, and I don't want to over obligate my seller. So make sure I have this right. And I know we can't say amounts.
Mm-hmm.
So if the amount if I represent the seller, if the amount in my listing agreement is X, and that matches the buyer's rep, those amounts are matching, and my sellers agreed to pay at BAC. So I put that, I understand, in the 12A1B. I get that. So then we're good. So I don't need to do
Hold on, Carrie. Hold on, Carrie. John, we go to that slide of the listing agreement where it's 5A and 5B? I think this will help wrap it up because I want to, I just want to be real picky about the words we're using, like seller and broker. So let's kind of wrap this up and frame it up. The first question is, what's in your listing agreement? Did the listing brokerage choose to participate in broker to broker with a 5A option in their listing agreement or 5B? So for example, you may have had a broker that says, I'm just going to have an agreement with you, seller, on what you're going to pay me to represent you and serve, that's it. I'm going to be representing and working for you. And we're not going to lay any cards, any amount of money, whether it be concessions or buyer's agent compensation. We're not going to lay any amount out there. And if I went with 5B, I also could use that other form 1412 where we get the seller's authorization. And I might say something in that form 1412 seller's authorization, something like seller will consider concessions or compensation conditioned upon acceptable offer. So that when the buyer's agents ask me, is BAC being offered? I'm communicating whatever is in my listing agreement. So what I heard you say, Carrie, I believe, is that in your listing agreement, you have elected for 5A, where the broker had offered an amount of compensation. Is that right? Or was it the seller that was offering compensation?
Probably worded it wrong. Seller.
Okay. So if the seller is offering, what I would guess is in the listing agreement, it was 5B, and then the buyer agent asked, hey, is anything being offered? And they had approval from the seller to communicate that the seller was offering to cover buyer's agent compensation. And then the buyer's agent would put that in 12A-B, saying, hey, this is the amount. The seller may have communicated it or not, but ultimately the buyer wanted to ask for the seller to pay for their buyer's agent compensation, and they put it in 12A-B. So did that help wrap that up? And John, would you like to clarify any detail there?
That's a great way of looking at it. What did the parties underneath the seller specifically agree to pay and how to pay it? If it's out of their own pocket, 12A1B. If it's cooperative comp, that should be the 2402. But in your specific hypothetical, there's the seller's agreeing to pay it. It's not through the cooperative comp, not through 5A. And so putting that in 12A1B would establish that obligation.
That helped. You just gave me the opportunity to kind of wrap it up and put a bow on it. So that worked out. All right. Any other additional questions? Hey, thanks a lot. Y'all stay warm out there.